What do you think? Is hanging to death a criminal on death row? Is an inhumane act? For 40 years, the Supreme Court of India has held that the mode of executing prisoners by hanging cannot be termed too cruel or barbaric, but now it has ordered to find out if there is a more dignified and less painful method to carry out death sentences. The Supreme Court has directed the central government to study and report on more suitable humane methods of execution that ensure a painless death instead of death by hanging. The bench comprising Chief Justice D.Y. Chandrachud and Justice P.S. Narasimha was responding to a public interest petition filed by a lawyer seeking a ban on gallows for convicts. The order said that the central government should inform whether hanging is appropriate in the modern age of science and technology. And if it does not happen, the court itself will form a committee for this purpose. The sender should submit a proposal in this regard after studying the alternatives and holding discussions with the public. Some say that as the world changes, such primitive methods of punishment must also be changed. Whether or not the death penalty should be used has been debated within the legal community for years. Courts impose the death penalty only in the rarest of rare cases now. In most cases, high courts and the Supreme Court have been granting commutation to the death sentences passed by lower courts. But even in cases where the Supreme Court has upheld the death penalty, there are still many hurdles to overcome before implementing the verdict. If a decision on the mercy petition submitted to the President is delayed, the death sentence will also get postponed. There is also an opinion that it is inhumane to carry out the death sentence after the person sentenced to death has spent 30 years in prison. Therefore, in such cases, the trial, appeal, and other proceedings should be completed within the stipulated time frame, given the legal maxim that justice delayed is justice denied. The justification for the imposition of the death penalty is the thought that there is nothing wrong in taking the life of a person proven to have committed unpardonable crime. The idea of finding an alternative mode of execution has been part of the wider debate on whether the death penalty should be abolished. The bench has sought fresh data to substantiate the argument that a more humane means of execution can be found. There are two leading judgments on the issue. Bachan Singh versus State of Punjab, 1980, which upheld the death penalty but limited it to the rarest of rare cases, and Deen Dayal versus Union of India and others, 1983, which upheld the method by ruling that hanging is as painless as possible and causes no greater pain than any other known method. The 35th report of the Law Commission, 1967, had noted that while electrocution, use of a gas chamber, and lethal injection were considered by some to be less painful, it was not in a position to come to a conclusion. It stopped short of recommending any change. Even though the Supreme Court has not favored abolition, it has developed a robust and humane jurisprudence that has made it difficult for the executive to carry out death sentences. The central government contends that the hanging should be retained not only because it is not cruel or inhuman, but also because it accounts for the least number of botched-up executions. Now it is for the public to debate whether hardcore criminals, habitual offenders, or barbarous rapists should be hanged to death or given deaths that is lesser painful and more dignified. I am KC Ashok signing off, and write your opinions in the comment box below or write to us at kaumudyglobal@gmail.com.